Hello guys and welcome back to the Law on Obligations and Contracts. So nandito tayo para sa isang short video tungkol sa Defective Contract. So ito po ay introduction lamang dun sa apat na Defective Contracts natin. So this is based from the Civil Code Article 1380 to 1422. So let's start with Defective Contracts. So last time, nabanggit natin na there are different classifications of contracts according to their binding power. So nandun nga po ang apat na defective contracts together with a valid contract. However, hindi na po natin isasama ang valid contract sa discussion na ito dahil automatically naman kung hindi siya nagfo-fall dun sa apat na defective contracts natin, ibig sabihin that is a valid contract. Okay? So ayan. So we have 4 defective contracts. We have the rescissible, voidable, unenforceable, and void. And actually, hindi po coincidence na ganito yung kanilang pagkakasunod-sunod, pero yun nga, yung kanilang pagkakasunod-sunod ay based on their binding force, sabi nga natin. Okay? Pag valid, nasa top of the list siya, wherein, ibig sabihin, 100% binding siya. Okay? Pero, habang pababa tayo sa listahan, okay, the more na hindi na nagiging binding ang contract. Actually, pagdating natin sa void contract, ito po ay walang binding na, okay? Ang void contract ay hindi na po siya binding at all, okay? Pagdating rin natin sa unenforceable contract, yung unenforceable contract, initially hindi rin siya binding, pero may chance na maging binding pa siya. Okay? So, hindi po incident na ganyan po ang pagkaka-arrange. Ibig sabihin, void, pinaka hindi binding, unenforceable, yung susunod sa void, and so on and so forth. Okay? So, meaning, ang medyo malakas-lakas pa dyan is yung rescissible. Okay? Compared to the next 3 types of contracts natin. Okay? So, meron tayong dito, table to compare the validity, the binding, and the enforceability of each, okay, of each defective contracts. Okay, so we have rescissible contracts are still valid, binding, and enforceable. Okay, so meaning kapag meron tayong examples ng mga rescissible contracts in the future, tatandaan nyo. Okay? Tatandaan nyo, valid, binding, and enforceable pa rin yung mga yan. Okay? Ibig sabihin, may effect yung mga yan kasi makikita nyo dyan yung word na binding and enforceable. Kung ano man ang nakasulat doon sa contract, mababind pa rin yung mga involved na parties at magiging enforceable yun laban sa kanila. Okay? If ever meron di ba, mga provisions yung contract natin. Okay, pagdating din ng voidable, ganun din. Lahat ng mga magiging examples natin, pagdating sa mga next videos natin, lahat ng mga voidable contracts are still, just like the rescissible contracts, are still valid, binding, and enforceable. Okay? And next, unenforceable contracts. Okay. So, unenforceable contracts are still valid contracts. However, they are not binding and enforceable against the parties, di ba? So, kung sakaling nagkaroon tayo ng unenforceable contract, hindi natin yun pwedeng ma-enforce, okay? Ma-enforce dun sa kabilang party, or hindi natin, kung ano man yung nakasulat dun sa contract, hindi natin pwedeng kunwari, may nakasulat doon na maningil ng ganito, hindi natin pwedeng enforce yun laban dun sa kabilang party kasi hindi naman pala enforceable yung contract, okay? So, ganun yung mga unenforceable contract. Pero, bakit valid siya? Okay? So, later on, pagdating natin ng unenforceable contract, malalaman natin kung bakit siya valid. Actually, yun lang yung pagkakaiba niya from a void contract. Kasi ang void contract, yung tatlong columns, naka-X po siya lahat, hindi na nga siya valid, hindi siya binding, hindi siya enforceable. Ibig sabihin, wala siyang effect. Okay? Kahit ano. Okay? Hindi nga siya valid. Okay? So, ito yung pagkakaiba lang ng isang unenforceable contract and void contract. Malaking pagkakaiba na to. Okay, pagdating ng yung magiging example natin on future videos. Okay? Okay, so next, another comparison. So, i-compare natin sila kung bakit, for number 1, bakit defective yung contract. For the next column or row, I mean, can it be ratified? Okay, so, lagyan natin ng yes. So, this must be no. Okay? Okay. So, ayan. Unahin muna natin yung why defective. Unahin muna natin yung rescissible contract. Bakit nga ba defective ang isang rescissible contract? Okay. Pagdating natin ng rescissible contract, actually, ang sasabihin ko dyan is, hindi naman talaga defective ang isang rescissible contract dahil walang defect sa anumang components ng isang rescissible contract. However, the mere existence of that rescissible contract causes damage to a third person. That's why it is considered defective with quotation, di ba? So yun, hindi naman talaga siya actually defective yung mismong contract. However, its very existence causes damage to another person, specifically third persons, okay? Or actually, kahit hindi third person, may chance na it causes damage to one of the contracting parties, okay? So those are rescissible contracts. Hindi talaga siya valid, pero I mean hindi siya talaga defective, pero kinonsider siyang defective dahil it causes damage to another person. Okay, it may be a third person or maybe one of the contracting parties. Okay, next. Why voidable contracts are defective? Okay, specifically kasi yung consent ay defective. Pagdating natin sa voidable contract, okay, lahat ng magiging examples natin ng specific defective contract na yan ay merong problema sa consent. Okay? So, nandyan yung for example, yung mga incapacity ng mga pumapasok sa isang voidable contract, 'di ba? Incapacity pag pumasok ng isang minor sa isang contract, so voidable 'yon. Okay? Kapag merong mga presence din ng tinatawag nating vices of consent, which is nabanggit natin last time pero hindi pa natin siya masyadong na i-detail sa discussion, okay? Next naman, why is an enforceable contract defective? Because it lacks authority or the necessary form. Napag-aralan natin last time dun sa forms of contract na there are certain contracts that require certain forms to be enforceable, di ba? So, meron tatlong reasons kung bakit ang mga contracts natin ay nasa isang certain form: for validity, for enforceability, di ba? Which is in this case unenforceable contracts, and lastly for convenience, okay? So, ito rin yun, okay? So, it may lack the authority, okay? There may be a lack of authority, okay, of the contracting parties, of one of the contracting parties, or, okay, or it lacks form, okay? Required by, di ba, yung tamang form for its enforceability. Okay, so void naman, okay, usually, there is a missing essential element, okay? Bakit siya nagiging effective? Merong missing essential element. So, it hinders it from being a perfected contract actually. Okay, so ang void contract ay hindi po valid contract, okay, for the very reason na hindi siya na perfect kasi merong missing essential elements, okay? So, dyan nag-fall yung mga illegal yung object or illegal yung cause, yung mga hindi talaga nagkaroon ng consent. Okay, dyan din mag-fall yung mga certain contracts which require certain forms for their validity na hindi nasunod. Kasi 'di ba nga, pag yun na ang magiging reason nung formality, okay, kailangan matupad yun. Or else hindi magiging valid yung contract, okay? Meaning yung form na yun isa na rin sa essential element ng specific contract na yun, okay? Just like a real contract na in addition to COC, kailangan na din ng delivery as an essential element kung maaalala nyo pa. Okay? So, yan yun. Yung pangalawang row naman, ano yung can be ratified? Pag sinabi nating ratified, pwede ba nating ma-cure yung defect? Okay, actually, ratification, okay, kinu-cure natin yung defect. Okay? Kinu-cure natin yung defect. Pagdating sa rescissible to unenforceable, yes, pwede pa nating ma-cure yung defect. Okay, kapag nagkaroon ng ratification. So, later on, sa mga future videos, i-explain natin kung paano ma-ratify ang bawat contracts na yan. Okay? And ang pagkakaiba lang dito sa specific row na to is yung void contracts. Hindi daw siya pwedeng ma-ratify. No ang sagot natin. So, na-typo lang tayo ulit. So, no yan. Okay? Hindi pwedeng ma-ratify ang isang void contract. Kasi in the first place, walang valid contract na pwedeng i-ratify. Yun yung very reason dyan kung bakit hindi pwedeng i-ratify ang mga void contracts. Okay? Next, punta naman tayo sa mga applicable provisions. Itong mga applicable provisions na to na in-specify natin sa specific row na to, okay? Ito yung mga nag-list down ng mga specific contracts na magfo-fall sa mga bawat defective contracts na to. So, for example, under Rescissible, pag binasa nyo yung Article 1381, lahat ng binanggit niya doon, yun yung mga specific contracts na magfo-fall under Rescissible Contracts. And ganun din sa Voidable, 1390, 1403 naman sa unenforceable, and 1409 naman pagdating sa void contract. So, yung mga yan, i-explain natin yan in detail sa mga future videos ng bawat defective contracts na ito. And lastly, okay, what is the remedy to avoid this contract? When we say to avoid the contract, to make it invalid, okay? To make it invalid, kasi kung maaalala nyo, di ba, sabi natin, from rescissible to unenforceable, valid pa rin yung mga contracts na yan. Kung maaalala nyo, di ba? Valid pa rin yung mga contracts na yan. Okay? Whereas, yung void naman, initially, hindi siya magiging valid kasi void na talaga yan from the start. Okay? So, in remedy to avoid, kung mapapansin nyo, not applicable yan. Okay? Kasi we don't need to avoid it kasi it's already avoided. Kasi hindi naman siya talaga na perfect actually. Okay? So, next, punta naman tayo sa mga other contracts. Ito namang unenforceable. So, despite being valid, bakit hindi natin kailangan? Okay, walang remedy to avoid this contract because although it is valid, it does not have any effect, di ba? Kung maalala niyo yung kanina natin, unenforceable contracts are not binding and not enforceable. Kaya nga nandiyan yung word, kaya nga yung mismong pangalan ng contract is unenforceable kasi hindi siya enforceable. Okay, so ibig sabihin walang effect yan sa mga contracting parties. So there's no need to avoid this contract kung wala naman effect. Okay? However, bakit siya nagiging valid? Okay, so masasagot na natin yung tanong natin kanina, which is, ano bang pagkakaiba nitong enforceable at void? Wherein, yun nga, valid ang unenforceable, pero hindi valid ang void. Okay? Because, nandito tayo, yung sa pangalawang row natin, which is yung ratification. Okay? Actually, ang mga pwede lang talagang i-ratify na contract ay mga valid contract. So, dyan nag-fall, okay? Yan yung naging pagkakaiba ng unenforceable from void. Yung unenforceable kasi, valid pa rin siya. Okay, so pwede siyang i-ratify. Pag sinabi natin i-ratify, makikure yung defect, meaning magiging fully perfected contract siya, fully valid contract siya. Okay? However, a void contract kasi, in the first place, hindi siya valid, hindi siya perfected. So, meaning, hindi siya pwedeng i-ratify. Okay? So, yun. So, sana naintindihan nyo kung bakit hindi na natin kailangang i-avoid ang isang unenforceable contract. Kasi in the first place, wala naman siyang effect. Hindi siya binding, hindi siya enforceable. Yung void, mas lalo. Kasi hindi nga siya valid. Okay? Next, punta naman tayo sa rescissible and voidable. So, paano i-avoid ang rescissible? Through the process of rescission. Okay? Ibig sabihin, kapag nirescind natin ang isang rescissible contract, mawawalan siya ng effect. Okay? From a perfectly valid contract, hindi naman perfectly valid, from a valid contract, mawawalan siya ng effect. Ibig sabihin, para na rin siyang as if magiging void contract na siya. So, once na nirescind natin ang isang rescissible contract, mawawalan siya ng effect, mawawalan siya ng validity, o parang magiging void contract na siya. Okay? Yun nga lang, ang pagkakaiba kasi, yung void contract, from the start, hindi na siya na perfect, hindi na siya naging valid. However, yung rescissible, initially naging valid siya. Tapos, nirescind lang natin, dun lang siya naging invalid. Okay? Ganon din sa voidable contract. Iba lang yung pangalan na ginamit natin, pero basically, same yung magiging effect kapag inannul natin ang isang voidable contract. Okay? So, pag inannul natin isang voidable contract, kung mapapansin nyo, ang voidable contract in the first place, ito ay valid, binding, and enforceable, di ba? Okay? However, pag inannul natin yan, magiging invalid na rin yan. Okay? So, wala na ring effect yung specific contract na to once na na-annul. Yung nga lang, pagkakaiba niya from a void contract, yung void, in the first place, na talaga siya, invalid na talaga siya. However, voidable are initially valid contracts. Okay? So, yun yung pagkakaiba ng mga different defective contracts natin. Okay? At ito yung video na magsisilbing overview dito sa mga 4 na defective contracts na to. Okay? So, later on, yung mga susunod nating videos, will in detail discuss each one of these defective contract. So mag-umpisa tayo on our next video on rescissible contracts. Ano nga ba ang rescissible contracts at ano nga ba ang nilalaman ng Article 1381? Okay? So see you next guys sa next video natin under rescissible contracts. Okay? So nandito na nga tayo sa yung mga detail ng ating defective contract. So, specifically, rescissible contract tayo, okay? So, konting ano lang tayo, konting, what do you call this? Recap from the last lesson. So, ayan. So, ang focus natin for today is rescissible. So, this is based on Civil Code 1380 to 1389. So, sabi ng 1380, actually, rescissible contracts are valid, okay? So, ayan. Okay, makikita nyo dyan. So, next, another recap, yung table natin, which compare the 4 defective contracts. So, ito tayo ngayon, rescissible contracts. Tatandaan natin na why rescissible contracts are defective, because it causes damage to third persons. Can it be ratified? Yes. And what are the applicable provisions, or ano yung mga examples ng ating mga rescissible contracts? This can be found on Articles 1381. Okay? So, what is the remedy to avoid the contract? So, it is rescission. Okay? So, let's start. Article 1381, the following contracts are rescissible. So, there are 5 instances na nabanggit dito. Number 1, those which are entered into by guardians whenever the ward whom they represent suffer lesion by more than 1/4 of the value of the thing which are the object thereof. Okay. Number 2, those agreed upon in representations of absentees if the latter suffer the lesion stated in the preceding number. So, number 1 and number 2 are somewhat related and similar. Okay. Number 3, those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. Number 4, those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. And lastly, number 5, all other contracts especially declared by law to be subject to rescission. Okay, so marami pa tayong makikitang rescissible contracts once na napuntahan natin yung mga other nominate contracts such as contract of sale and contract of agency and partnership, and marami pang iba, okay? Pero for now, generally, yung 1 to 4 na mga situations, ito yung mga, rescissible contracts, okay? So, isa-isahin natin. Number 1, magbigay tayo ng example para mas maintindihan natin. Number 1, so, ayan, example natin is, G is the guardian of W, the ward, okay? So, ito yung nabanggit na ward dito sa ating Article 1381, so ward, tapos si guardian, okay? So, dalawa yan. So, G sold to X the property. So, si X ay isang third person. Sold to X the property of W for 250,000. The value of the property is 500,000, okay? So, ganito. Sa pag-analyze nito, dapat tugma ito sa number 1, okay? Tugmang-tugma. Kasi, tignan nyo mabuti, okay? Kasi madalas sa mga exams natin and quizzes, okay, may konting babaguhin lang dito. Sa example, may konting babaguhin lang dito. Maaaring hindi na siya rescissible kasi hindi siya tugmang-tugma doon sa binabanggit or nakastate doon sa Article 1381. So, i-analyze natin. Ang nagbenta, sino? Si guardian. Okay, si guardian. Kasi nakalagay dito sa number 1, those which are entered into by guardians. Okay? Whenever the ward whom they represent suffer lesion by more than 1/4 of the value of the thing, okay? At ang ginagamit nilang object of the contract is pagmamay-ari ni ward, okay? So kung mapapansin niyo dito, G sold to X the property of W, okay? So dapat present yung mga nabanggit na natin yan. Si G ang nagbenta, okay? Ang binenta niya yung property ni W, okay? Iba na ang magiging situation kapag si X na mismo ang nagbenta ng kanyang sariling property. Or si G, binenta niya property niya, hindi property ni Ward, okay? So, malinaw na malinaw. Yun ang titignan natin dito para maging rescissible yung contract. And lastly, natitignan natin is yung nagkaroon ba ng lesion. So, what is lesion? Ano ba yung lesion? Actually, this is the inadequacy of the cost. Okay? Inadequacy of the cost. So, in this case, the price of the property, which is 250,000. Pag titignan natin, clearly, the price of the contract of sale is inadequate compared to the value of the property na binenta. So therefore, the ward suffered lesion in this case. So pero merong binanggit si Article 1381, very specific siya. Dapat more than 1/4 ang naging lesion. So kung makapansin nyo, ilan ba ang naging lesion? Actually, 1/2 pa nga eh. So more than 1/4 na yon, di ba? Okay, so ang lesion, kasi ang inadequacy kasi, 500,000 minus 250,000. So, ang kulang is 250,000. So, 250,000 divided by 500,000, o 1/2 na yon. So, that is already more than 1/4 of the value of the thing. Okay? So, that is the lesion. So, in this case, our example is a rescissible contract. Okay? So, next, punta tayo sa second scenario na binanggit ng Article 1381. So, what's the second scenario? Okay? Actually, the second scenario is very related to the first one. Ang nangyari lang is pinalitan lang natin si R, pinalit natin si R, ang pinalitan niya ay si guardian. Kung makapansin nyo, di ba? At pinalitan natin si A, absentee, ng sino? Sino ang pinalitan natin dito? Si ward. Okay? So, by the way, nakalimutan kong banggitin, si ward dito, kaya hindi siya yung mismong nakikipagkontrata dahil usually kapag ward, okay, yan ay isang minor. Okay, minor yan. Okay, pag sinabi nating ward, minor pa lang yan. Hindi siya pwedeng makipagkontrata. Okay, so balik tayo dito. In this case naman, bakit nakikipagkontrata din ay si representative? Kasi A, absentee. Wala siya. Hindi siya present, di ba? Okay, so meaning, yung representative niya ang makikipag-transact ng kung anumang business meron si A. Okay, so in this case, binenta ni R yung property ni A kay X. At kung mapapansin nyo, nag-suffer ulit ng lesion. Okay, so kung mapapansin nyo, very similar lang yung number 2. Okay, so inuulit ko, sa number 2, ang nagbenta yung representative. Ang binenta niya yung property ni absentee. Okay? At nag-suffer si absentee ng more than 1/4. Ganun din, more than 1/4 tong number 2 din. Kasi sabi niya dito, if the latter suffer the lesion stated in the preceding number. Okay, so that is number 1. Okay, so in this case, this is a rescissible contract. So by the way, binabanggit natin, this is a rescissible contract. Sino ang pwedeng mag-rescind ng rescissible contract na to? Obviously, ang pwedeng mag-rescind ng rescissible contract na to ay, okay, unahin natin yung number 1, syempre si ward. Once na na-attain niya na yung age of majority or naging 18 years old and above na siya. So, doon niya na pwedeng mapa-rescind yung contract. Pero, don't worry, kahit na let's say 5 years old pa lang yung ward na yan, bibigyan naman siya ng sapat na time ng batas para mapa-rescind yung contract. Okay? Ganon din si absentee. Okay? Si absentee, siya yung pwedeng mag-rescind ng contract. Okay? At sa kanyang case din, bibigyan din ng sapat na time si absentee para i-rescind yung contract. Okay? So, mag-i-start yung time na yon from the time na hindi na siya absentee or basically kapag yung knowledge na nabenta yung kanyang property ay napunta sa kanya. Okay? And at that moment, syempre magpapakita na siya or kakausapin niya na si R. Okay? So, next, number 3 tayo. Those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. Okay, so let's have an example. So, D is a debtor of C, the creditor. Okay, so fearing that he won't be able to pay his debt to C and his land being levied, D sold his land to X without the intention of using the proceeds to pay C. So, clearly, okay, we have a clear act of defrauding C in this case. Okay, so therefore, yung ginawang pagbebenta ni D kay X, that is a rescissible contract. Okay, So, sino ang pwedeng magpa-rescind? Si C. Okay? In this case, si C ang pwedeng magpa-rescind. Okay? So, next, number 4, those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. Okay? So, any contract having their, with an object that is under litigation is rescissible by the other party. So, for example, S sues B for the recovery of a parcel of land. Okay, so, in this case, the land na pinag-aawayan dito ay effectively a thing under litigation. So, lahat ng contract na ma-involve itong land na ito, magiging rescissible. Siyempre, except if it is authorized by the court, di ba? Nabanggit naman kasi dito. Okay, suppose B, si B, binenta niya yung land na yan kay X. Okay, so ano mangyayari? Yung contract between B and X will be a rescissible contract. Okay, pero inuulit ko, okay, ang rescissible contract ay valid, binding, and enforceable. Okay, pero pwede siyang i-avoid or pwede siyang ipa-rescind. Okay? So, ayan. Punta naman tayo sa difference between rescissible contract and rescissible payment. So, ang rescissible contract basically is a contract, di ba, na pwedeng i-rescind. However, ang isang rescissible payment ay based lang sa Article 1382. So, basically, payment lang siya na pwedeng ipa-rescind. Okay? So, ang example natin dito, D, while insolvent, pays X his debt. Y and Z are also creditors of D, but cannot in any manner collect from D. Okay, so ang key concept na titignan nyo dito is, ayun nga, okay, nagbayad, okay, nagkaroon ng payment, okay, during a state of insolvency. Kung mapapansin nyo, yun nga, state of insolvency yung binanggit dito. So, D, while insolvent, pays X his debt. Okay? Okay, so in this case, sino ang pwedeng magpa-rescind? Okay, so malamang-lamang yung mga other creditors ni D kasi hindi lang naman si X yung creditor niya dito. So, ang nangyari dito is, yun nga, insolvent si D, pero binayaran niya yung iisang creditor lang. So, yung mga other creditor, ang mangyayari is, mas lalong hindi sila makakasingil. Kasi insolvent na nga, tapos yung mga natitirang pagmamayari niya, ibinayad niya sa isang creditor who is not, let's say, who is not preferred. So, may karapatan yung iba na, oh, bakit ganyan? Okay, so, pupunta sila sa korte, ipapa-rescind yung contract na yun. So, pwede, okay? So, Y and Z are also creditors of D but cannot in any manner collect from D. So, Y and Z are affected by the contract, okay? Actually, by this payment, specifically kasi rescissible payment ang pinag-uusapan natin. So, yun nga. There's nothing wrong with the payment. However, okay, yun nga. There's nothing wrong with the payment itself. However, it affected third persons, okay? Or it causes damage to other person. Okay, Y and Z may not, okay, be able to collect in the future if, yun nga, hindi nila na-rescind dito. Okay? So, next. Okay, next. So, kanina pa natin binabanggit yung word na rescission. So, under Article 1383, so sinasabi dito, the action for rescission is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation of the same. So, sabi nga natin, ang rescission ay isang method para ma-avoid yung contract. So, when we say to avoid the contract, ang mangyayari is mapapa-invalidate natin yung contract or yun nga, from being a valid contract, valid, enforceable, and binding contract, magiging parang as if parang magiging void na siya. Pero yun nga, pagkakaiba ng contract na ito is yung void kasi from in the first place hindi na wala na siyang effect. Okay, hindi na siya valid, hindi siya enforceable, hindi rin siya binding. Okay? So when we say rescission, we end the validity of a certain defective contract. So in this case, we are referring to a rescissible contract. Okay? Pero ano yung sinasabi niya dito na rescission is a subsidiary. Okay. Actually, last time kasi nabanggit din natin yung yung word na annulment, which is another method of avoiding a defective contract, pero specifically voidable contract. So anong pagkakaiba ng rescission from annulment? Yun nga, okay. Actually parehas sila ng effect. Ina-avoid nila yung contract, i-invalidate nila yung mga contracts na yan, okay? Pero sa claim or sisik ng remedy na ito, yun nga, may malaking pagkakaiba. When you seek rescission, it is only a subsidiary remedy compared to annulment, which is a primary or principal remedy. Okay, ano bang ibig sabihin ng pagiging subsidiary remedy nito? Okay, so let's have an example. G is the guardian of M. Okay, so itong example natin. A minor with 2 parcels of land valued of 200,000 pesos each. However, binenta ni G yung 2 properties to B for only 200,000. So, supposedly 2 parcels yan times 200,000. So, dapat 400,000 yan in total. Okay, pero binenta niya yung dalawang yan for only 200,000 buo na. Okay, so ang nangyari, nagsuffer ng lesion si ward natin, okay, ng 1/2, di ba? So, it is already more than 1/4 of the value of the thing. Okay, so in this case, ang mangyayari is, yun nga, rescissible itong contract na ito. Pero ano ba yung subsidiary na yan? Okay, so, si M, kapag na-attain niya na yung age of majority, pwede niyang ipa-rescind yung contract na yan. However, rescission nga, subsidiary lang. Ibig sabihin, hindi mo siya pwedeng ma-employ kapag, hindi mo siya pwedeng ma-seek or hindi mo siya pwedeng magawa kapag meron kang other option. So, for example, okay, willing naman pala si B na bayaran yung lesion ng, di ba, yung lesion na 200,000. Willing siya na bayaran yon. Okay? So, in that case, hindi mo na pwedeng ipa-rescind itong contract na to kasi willing naman pala siyang bayaran yung lesion. Okay? To make the contract not a rescissible contract. So, therefore, yun nga, subsidiary lang yung, yung action for rescission mo. Okay, so pag may other remedies such as this, yung binanggit natin, yung willing magbayad yung third person na yan, yun nga, ang mangyayari is hindi mo pwedeng i-invoke yung action for rescission na yan. Okay? So, punta naman tayo sa extent of rescission. So, this is based on Article 1384. Rescission shall be only to the extent necessary to cover the damages caused. Okay? So, para mas maintindihan natin, let's take an example. Actually, this is the example kanina, which is really meant for this specific provision. So, G is the guardian of M, a minor with 2 parcels of land valued of 200,000 each. So, G sold the 2 properties to B for 200,000. So, in this case, kung mapapansin nyo, rescissible itong contract na to. Just like as I explained earlier, di ba? Kasi supposedly 2 parcels to times 200,000, so it should have been 400,000, pero binenta niya lang for 200,000. So in this case, ganito. Total yung isang property is worth 200,000. So meaning, kapag ipapa-rescind mo itong specific contract na ito, ang pwede mo lang mapa-rescind ay yung sale nung isang property. Okay, kasi yung isang property, okay siya. Kasi, di ba, 200,000, mako-cover naman nun yung napagbentahan or yung supposed value nung isang parcel of land, di ba? Kasi 200,000 each sila eh. So, ibig sabihin, kapag nagbayad ng 200,000, okay yung isang parcel of land. However, the other one, yun ang hindi okay. So, yun lang ang pwedeng mapa-rescind natin in this case, okay? Meaning, yung sale ng isang parcel of land, valid na yun. Hindi na yun pwedeng maparisin. Kay B na yun. Okay? So, there's no way for M of claiming rescission over that land. Okay? Ang pwede na lang is yung isa. Okay? Kasi doon nag-suffer talaga ng lesion. Actually, doon na natin nilagay lahat. Okay? Na supposedly, di ba, dapat hati sila. Pero, yun nga, Sabi dito, to the extent necessary lang to cover the damages caused. Okay? So, kung hindi naman na necessary na pati yung isa pa na paghatian nila, yung isa lang, yung rescission lang nung isang parcel of land in this case. Okay? So, that is Article 1384. Okay, so for rescission to be possible, okay. So, sabi dito, kailangan kapag nagkakaroon ng rescission, okay, ang main idea dito is kapag nagkakaroon kasi ng rescission as if wala tayong contract, okay? So kung as if wala tayong contract, kung ano man yung mga naibigay natin sa bawat isa, kailangan natin yung ibalik, okay? So yun yung sinasabi dito actually. So rescission creates the obligation to return things which were the object of a contract together with their fruits and the price with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. Neither shall rescission take place when the things which are the object of the contract are legally in possession of third person who did not act in bad faith. In this case, indemnity for damages may be demanded from the person causing the loss. Okay? So, yun. Kapag magsisig ka ng rescission, be sure, okay, to return whatever you may have received by virtue of the contract, di ba? Kasi required muna yun, okay? So, ayan, may example ata tayo. So, B asks for the rescission of the sale with S because of breach of warranty against hidden defects. Okay? So, kapag ipapa-rescind mo as a buyer, yung sale na yan, so make sure na kaya mong maibalik yung specific object nung contract of sale na yan dun sa seller. Kasi kung hindi, yun nga, hindi possible ang rescission in that case. Okay? Pero syempre, pagdating natin sa sales kasi may mga other specific mga specific provision doon wherein, 'di ba? What if nawala yung bagay na yun, nagkaroon ng total loss by reason of that hidden defect. So medyo advanced topic na yun pagdating sa sale. So mga what ifs na yung mga yun, okay? So ang assumption lang natin dito, may hidden defect nakita mo, nasa sayo pa rin, okay? So pwede mo pang maibalik. So in that case, you may still ask for rescission, okay? So, rescission not possible for contracts approved by court. So, kapag inaprubahan ng court, so, okay, approve, okay, pwede mo tong gawin, pwede mo tong ibenta, okay, so, wala kang magagawa, hindi magiging rescissible contract na yun kasi inapprovean pala ng court. So, rescission referred to in numbers 1 and 2 of Article 1381 shall not take place with respect to contracts approved by court, okay? So, hindi pwedeng magkaroon ng rescission. So, balikan natin yung number 1 and number 2, yung kapag si guardian, okay, kapag in-approve ni court yung pagbebenta ni guardian ng property ni ward sa ganitong halaga, so hindi yung magiging rescissible. Ganon din dito sa representative and absentee. Okay? So, contracts presumed to be rescissible. Okay? So, what are the contracts presumed to be rescissible? Article 1387, paragraph 1. All contracts by virtue of which the debtor alienates property by gratuitous title, so gratuitous yung contract natin, are presumed to have been entered into fraud of creditors when the donor did not reserve sufficient property to pay all the debts contracted before the donation. And paragraph 2 and 3, so alienations by onerous title naman, so this specific paragraph deals with onerous contracts, are also presumed fraudulent when made by persons against whom judgment has been rendered in any instance or some writ of attachment has been issued. The decision or attachment need not refer to the property alienated and need not have been obtained by the parties seeking rescission. In addition to these presumptions, the design to defraud creditors may be proved in any manner recognized by the law of evidence. Okay? So, example tayo para mas maintindihan natin. So, yung first paragraph muna tayo when we are dealing with gratuitous contract, okay? So, D contracted several debts amounting to 200,000. Also, D has total asset of 300,000. So, kung mapapansin nyo, yung total asset niya, sufficient siya para mabayaran lahat yung utang, which is in total 200,000. Pero one day, D donated to X a property from his total assets worth 170,000. So, pag binawasan natin yung 300,000 ng 170,000, ang matitira na lang ay 130,000. And clearly, a total asset of 130,000 is not sufficient to pay the 200,000 debt. So, in that case, yung donation na ginawa dito ni D kay X ay presumed to be fraudulent. Okay? So, yun, pwedeng ipa-rescind pag eventually napatunayan nga talaga na fraudulent yan. Okay, so in fraud of creditors yan. So, magfo-fall yun sa third case natin dun sa Article 1381. So, magiging rescissible contract yung ginawang donation kay X. Okay? So, how about when we are dealing with onerous contract? So, D contracted several debts amounting to, so still the same, 200,000 with A and B. Also, D has 300,000 total asset composed of a car, land, and a building. Okay, so ayan. For whatever reason, suppose A obtain a writ of attachment on this land. Okay, so siguro hindi makasingil ito si A. Kaya yun, nakapag-obtain siya from the court a writ of attachment on this land specifically. Okay, so meanwhile D sold the car to X. Okay, so in this case, the sale of D of the car to X is considered fraudulent. Kung mapapansin nyo, it doesn't need that yung mismong car yung na-issuehan ng writ of attachment. Kung mapapansin nyo, ang na-issue ng writ of attachment ay land. So, it doesn't matter, okay? So, yung nabanggit dito doon kanina, di ba? Yung doesn't need, okay? Writ of, okay, the decision or attachment need not refer to the property alienated, okay? And also, okay, pag binalikan natin to, sino ang pwedeng magpa-rescind if ever, okay? So, ang affected dito actually ay si A kasi meron siyang writ of attachment, okay? Pero actually, pwede ring ipa-rescind ito ni B, okay? Kasi, yun nga, it doesn't matter kung sino yung naka-obtain ng writ of attachment, okay? So, in this case, pwedeng si A ang magpa-rescind nitong contract na to, pwede ring si B. Okay? So, ayan. Acquisition of third person in bad faith. Okay, Article 1388. So, let's read and may example. So, whoever acquires in bad faith the thing alienated in fraud of creditors shall indemnify the latter for damages suffered by them on account of the alienation. Whenever due to any cause, it should be impossible for him to return them. Okay, if there are two or more alienations, the first acquirer shall be liable first and so on successively. So kung maaalala nyo, kanina, kapag na-acquire ng third person yan in good faith, hindi na pwede ang rescission. Okay? So, example na lang tayo. To defraud C, S sold to B his car. B knows of S purpose. So, in this case, bad faith si B, isang third person. Okay? So, si C ba, pwede niya bang ma-recover yung specific, what do you call this, the car, okay? May balik kay, sino ba yun? Si S, may balik kay S yung car, tapos yun nga, parang mapapawalang bisa yung sale na ginawa ni S with B, okay? Kasi magiging rescissible contract siya. Okay, kasi in bad faith siya, okay? So, pwedeng maparisin yung specific contract na ito. Pero kung in good faith si B, itong third person na to, okay, in good faith si B, pero nakalagay kasi dito knows S purpose kaya bad faith. Pero kung in good faith yan si B, there's no way or the contract between S and B is not rescissible. It's perfectly valid. So hindi na pwedeng maparisin yun ni C kasi yun nga, binase natin yun from a previous article na nabasa natin kanina kapag yun nga napunta na sa third person in who acquired that specific property in good faith, hindi na magiging rescissible yung contract natin. Okay? So, ayan. So, another example tayo. Okay? To defraud C, S sold to B his car. B knows S purpose. So, B sold to D. Okay? Bad faith din si D daw. And D sold to E. Good faith naman si E. Okay? So, in this case, ganito. Dahil napunta, in this case, ang unang magiging liable, okay, sabi nung kasi natin, okay, if there are two or more alienations, okay, the first acquirer shall be first liable first and so on successively. Okay, so ang magiging liable muna dito, syempre, okay, syempre yung unang naging bad faith which is si B, okay? At kung hindi natin wala tayong parang kumbaga kasi na-alienate niya na sa sumunod Okay, ang susunod na magiging liable ay si D naman. Okay, pero hindi magiging liable si E kasi in good faith siya. Okay? So, what if ganito naman yung situation natin? Okay? So, in this case, inuulit ko yung second situation natin dito. In terms of liability, ang primarily magiging liable ay si B. Okay? Pero, kapag hindi natin ma-recover sa kanya yung specific car na yan, syempre, susunod kay D. Okay? At, syempre, eventually, mapupunta tayo kay kay E, pero, ma-found out natin na in good faith pala siya, so wala na. Okay, hindi natin ma-recover sa kanya kasi in good faith siya. Okay? So, ayun, yun yung second example. Pero in this third example, may pagkakaiba to kasi una pa lang, okay, in good faith si B. Pero yung mga sumunod sa kanya, okay, in bad faith. Okay? So in this case, dito pa lang wala na. Okay? Hindi na pwedeng ma-resin yung contract. Okay? Hindi na pwedeng ma-resin yung contract dito sa third statement or third example natin. Hindi na pwedeng ma-resin ni C yung sale of S ng car kay B. Okay? Kasi si B pala mismo, siya yung unang-unang alienation, okay, or transfer of the car ay good faith. Okay? So in this case, exemption to. Okay? Pero unlike yung number 2 and number 3, pwede pang maparisin yan. Okay? Pwede pang mariparisin yan. Pero ang pagkakaiba ng number 2 kasi, yung rescission, titignan natin, di ba? Titignan natin muna. Una kay B, pangalawa kay D, and panghuli si E. Okay? At dahil nung pagpunta natin kay E, we found out that he is in good faith, ang magiging liable na lang ay si B and D. If ever, 'di ba, nag-cause ng damages yung ginawa nilang acts dahil hinayaan nilang ma-alienate papunta sa kamay ng isang good faith na person. Ibig sabihin hindi na pwedeng ma-recover yung specific na yan. So yung acts ni B and D, it causes damage. Also, it causes damage to C. Okay? Hindi lang yung act ni C na lang ang nag-cause ng damage ni S, I mean. Kundi yung collective acts ni S, B, and D. Okay, so sila mananagot kay C. Okay, kung ano man ang masasuffer na damage ni C. Okay, pero in the first case kasi wala pang other involved, si B and S ang magiging liable for this rescissible contract. Okay? So last topic tayo for this video. So prescription of rescission. So, magpe-prescribe ba ang rescission? Of course, yes. Pag sinabi nating prescription, yan yung parang kumbaga may time limit ang pagre-rescind ng isang contract. Kung hindi mo siya maparesin kaagad, wala na. Okay? Magiging perfectly valid na yung contract natin. So, the action to claim rescission must commence within 4 years. Okay? 4 years. Malinaw na malinaw. However, syempre may exemption dyan sa 4 years na yan. So, generally 4 years. Pero, ang hindi lang 4 years ay itong mga to. For persons under guardianship and for absentees, the period of 4 years shall begin until the termination of the former's incapacity or until the domicile of the latter is known. So, yun nga, kung binalikan natin yung number 1 and number 2, ito yung guardian ward tapos yung representative absentee. So, in this case, yung number 1, yung sa case ng guardian and ward, mag-uumpisa lang na magbilang yung 4 years from the time na naging 18 years old na si ward. Okay? Para bibigyan siya ng chance para ma-rescind yung contract. Kasi, di ba, paano kung nangyari yung rescissible contract na yan nung 5 years old pa lang si ward, di ba? So, dumaan na ang 4 years, pero hindi pa rin siya 18 years old. Hindi pa rin siya pwedeng mag-enter into a contract. Hindi niya pa rin pwedeng maparesin. Okay? So, magbibilang lang yung 4 years from the time na mag-cease yung kanyang incapacity. And ganun din sa number 2. Okay? Siyempre, paano kung hindi niya pa rin alam? Kasi absentee pa rin siya hanggang ngayon, di ba? So, usually, yung 4 years, magbibilang siya from the time, yun nga, na malalaman niya na, yun nga, nag-suffer ng lesion yung ginawang transaction ng kanyang representative with regards to his property. Okay, so yun yung exemption natin dun sa prescription na 4 years. Pero generally, for example, numbers 3 to number 5, yung mga yan ay 4 years from the time the contract is perfected. Okay, so ayan. Coming up next will be voidable contracts.